So today, the Supreme Court made it harder to challenge unfair voting maps under the Voting Rights Act. And that really matters in Alabama. In Louisiana v. Kelly, the Supreme Court limited how people can use Section 2 of the Voting Rights Act, especially when it comes to racial gerrymandering. And considering political gerrymandering is totally fine, we've got big problems. Just in 2003, and then following that decision last year, the Supreme Court forced Alabama to redraw their districts because of the Allen v. Milligan case. In that case, they found that the Alabama maps diluted Black representation. That ruling is why Alabama now has a second opportunity district, the district that is represented by Shomari Figures. Today's decision makes cases like Milligan harder to prove in the future. What does that mean? It means the protections that created that second district are now weaker, and future challenges to unfair maps just got harder. And it means states across the South, including Alabama, especially Alabama, they face fewer limits when drawing districts. In fact, there is already talk on the ground about calling a special session to redraw the maps at this point. After Shelby County versus Holder, Section 2 became the main tool in order to fight these unfair practices. Now the court just narrowed that tool even more to the point that it's probably not even going to be useful anymore. Guys, this isn't theoretical. This is code red. Here's the problem. The representation that we have in Congress is what affects who represents your healthcare, your families, your schools, and your courts. Voting Rights Act protected representation for decades, and now it's basically gone.